There is a federal version and a state version of the Human Trafficking and Child Exploitation Prevention Act. This video explains both. Starting with the state bill. The state version of the Human Trafficking and Child Exploitation Prevention Act is divided into three parts. A resolution that declares that pornography is a public health crisis, the Human Trafficking and Child Exploitation Prevention Act, and the Admission Act. The resolution reframes obscenity online from a speech question to a health issue. It identifies the problem that the Human Trafficking and Child Exploitation Prevention Act solves. The next piece of the legislative package is the Human Trafficking and Child Exploitation Prevention Act itself. The bill states that going forward in the state at issue, any retailer or manufacturer of products that distribute the internet or make content accessible are going to have to install filters that automatically block prostitution hubs and X-rated material. If an adult consumer wants to have access to adult content, they can. They just have to show proof of ID to the retailer, express an interest to have access to the content, and pay any fee set by the retailer to deactivate, which creates a new revenue stream for business. There's also a separate fee that goes back to the state to be used to offset the secondary harmful effects cultivated by that content. Here's some key talking points for the bill. Number one, the United States Supreme Court found in Ashcroft versus the ACLU that Congress undoubtedly may act to encourage the use of filters. It can encourage parents to use filters, and it can encourage the tech companies to develop better filter technology. That was the United States Supreme Court telling the legislative branch to pass this bill. A second key talking point is that this bill is based off of the existing display statute, which all 50 states have. The display statute is the law that says that if you own a gas station or a newsstand, you can sell Playboys and Hustlers, but the retailer's got to put those behind a blind rack that can only be removed if the consumer is an adult, they show proof of ID, they pay for the content, they express a desire to have access to it. The United States Supreme Court upheld those statutes in a case called Ginsburg, finding that the display statutes survive First Amendment heightened scrutiny as the least restrictive means. The constitutional legal basis for the physical display statute is the same constitutional legal basis for the digital display statute, which this bill is. Probably the best talking point and a good way to start the legislative hearings is to begin by saying, why is it that a 12-year-old in the state at issue can't go see an R-rated movie, they can't buy a Playboy from the local gas station, but they can walk around with an X-rated theater in the form of a filterless iPhone that they got from the local Verizon store? It's a double standard that makes no sense. It's a crime right now to distribute pornography to minors. The two opponents of the bill have been the ACLU and the Retail Association, but we've met with both exhaustively. The ACLU's primary objection was that they want the in-writing requirement to deactivate to be removed. They were worried that a database could be created. We agreed with them and we struck those two words from the bill. And that has put to bed their opposition because they can't get around the decisions in Ginsburg and Ashcroft. The Retail Association is okay with this bill on two conditions. One, that they're all held to the same playing field, which this bill accomplishes. And two, as long as they can charge a filter deactivation fee, they're okay with the bill. So now I'll pivot to the federal bill. The federal version of the Human Trafficking and Child Exploitation Prevention Act says three primary things. Number one, it makes clear that in the event that there's a federal law that preempts the state's version of the bill, it does not. And by the way, there are no laws that do that. Number two, the federal bill requires that manufacturers of products that distribute the internet that cross state lines must first have activated filters installed with a password withheld. The manufacturers are required to provide the retailers within the states with the mechanisms to deactivate the blocking software, which will mean that the retailers within the states are automatically in compliance with the state versions of the bill. Number three, the federal bill requires the manufacturers of products crossing state lines to have to create a call center and reporting website so that when non-obscene content is accidentally being filtered, or if obscene content is not being blocked that's supposed to be blocked, that can be reported in, and the manufacturer can send out software updates to block or to unblock that content. So the state bill and the federal bill are synergistic, but the state bill is probably more important for three reasons. Number one, obscenity codes and prostitution codes are state laws. The physical display statute, which the bill is based off of, is a state law. Number two, we want the state courts to be able to enforce the act. And number three, we want the states to get the $20 filter deactivation fee so it can be used to offset the secondary harmful effects created by that content. That brings me now to the Admission Act. The Admission Act is a third piece of state legislation that we are rolling out as well. This is an act that says when you go to a strip club, you have to pay a nominal fee to get in. That nominal admission fee goes back to the state to be appropriated to the same pool of funds that the one-time $20 filter deactivation fee goes to. The strip club entrance fee and the $20 filter deactivation fee are not content-based. They are imposed so that the state can offset the secondary harmful effects cultivated by that content. The Supreme Court has found in cases like Paris Theater that states have a compelling interest to uphold community standards of decency. Furthermore, the Texas Supreme Court has upheld the Admission Act in Combs versus Texas Entertainment. The constitutional legal basis for the strip club entrance fee is the same constitutional legal basis for the one-time $20 filter deactivation fee. So these state and federal bills go go together as part of a legislative packet that will do more to fight human trafficking than any measure since the inception of the internet. Sex trafficking has gone from the street corner to the smartphone. This act will reduce crime, protect children, create new revenue streams for the state, a new revenue stream for business, reduce the size of government, reduce the prison population, and proliferate human flourishing. We ask that you support it.